Today, we're going to pull back the curtain on our legal system and look at the invisible rulebook that runs every single trial. The rules of evidence is the whole system that's designed to make sure verdicts are based on facts, not fiction. So let's dive right in.
You've seen it a million times in the movies, right? A witness is about to spill some juicy detail, and a lawyer just leaps to their feet yelling, "Objection!" Well, believe it or not, that's not just for the drama. They're actually using a really complex and super important set of rules that control every piece of information a jury gets to hear.
Here's the best way to think about it. A trial is like a high-stakes championship game. The lawyers, they're the players. The judge, they're the referee. And the rules of evidence, well, that's the official rulebook. Without it, the game would be total chaos, and the final score would be completely meaningless. These rules make sure the game is played fair and square.
So why do we even need this complicated rulebook in the first place? Well, its purpose isn't to confuse everybody. It's actually there to protect people by making sure the search for the truth is disciplined, focused, and, most importantly, fair.
At the end of the day, these rules really have one main mission: to filter out all the unreliable gossip, the rumors, and the personal biases so that decisions are based only on legitimate, proven facts. They're like a shield, protecting every single person from being judged on something they heard through the grapevine or on information that has nothing to do with the case.
The journey to get these rules was a long one. I mean, we went from these superstitious, pretty cruel methods like trial by ordeal, where, if you could hold a red-hot iron and your hand healed, you were innocent, to a system based on logic. After hundreds of years of courts kind of making it up as they went, a huge turning point came in 1975. That's when the Federal Rules of Evidence, or the FRE, were adopted, creating one single unified rulebook for all federal courts.
The entire philosophy of this massive rulebook can really be boiled down to one simple idea, which comes from Rule 402. If a piece of evidence helps prove a fact that actually matters in the case, it gets in, unless another specific rule exists to keep it out. And really, the rest of the code is just a giant list of all those unlesses.
So, let's talk about those unlesses. We obviously can't cover the entire rulebook today, but we can break down the three biggest, most important principles you'll ever come across: relevance, hearsay, and character evidence. These are the greatest hits.
First up is relevance. This is the main gateway for all evidence. If it's not relevant, nothing else matters. It's got to be thrown out. Think of it this way. In a bank robbery trial, evidence that the defendant was on vacation in another country, that is highly relevant. Evidence that the defendant hates broccoli, completely, totally irrelevant. It just has to have some logical connection to the case at hand.
But here's the twist. Even relevant evidence can be kept out of a trial. And this is where the law gets really interesting, because it admits that sometimes a piece of truth can be so emotional or so distracting that it actually prevents a fair trial. The judge's job, using Rule 403, is to do this delicate balancing act. They have to weigh how important the evidence is against the danger that it might unfairly prejudice the jury, confuse them with a side story, or, frankly, just waste everyone's time.
Okay, next up is the most famous rule of them all, hearsay. Now, the official definition is a bit of a mouthful. It's an out-of-court statement offered in court to prove the truth of the matter asserted. Yeah, confusing, right? Let's just simplify that a lot.
A much better way to think about it is the courtroom telephone game rule. You know, the game you played as a kid? If a witness gets on the stand and says, "My neighbor Bob told me he saw the defendant run the red light," that's hearsay. The court doesn't want to hear what Bob said secondhand. The court wants to hear from Bob himself, under oath, where the other side can cross-examine him. It's banned for one simple reason: secondhand information is just not reliable.
Now, of course, the hearsay rule is notorious for having dozens of exceptions. The law basically recognizes that there are some situations where an out-of-court statement is probably trustworthy. For example, an excited utterance, that's something someone blurts out during a super stressful event, that's often allowed in because there was no time to think up a lie. The same basic logic applies to things like dying declarations or routine business records.
And finally, let's talk about character evidence. This one is a huge protection for defendants. A prosecutor is not allowed to argue, "Hey, the defendant stole a candy bar 5 years ago, so he has the character of a thief, and that's why you should convict him of this new theft." That's called propensity evidence, and it's totally forbidden. The idea is that you're supposed to be judged on what you did in this case, not on who you might be as a person.
But just like with hearsay, there are some critical exceptions here too.
A person's past actions can be brought up for other, very specific reasons, and you can remember them with the handy acronym MIMIC. For instance, to show a motive for the crime, or to prove the defendant's identity because the crime was committed with a very unique signature method they've used before. See, the past act isn't being used to prove their character. It's being used to prove something specific about the crime itself.
Okay, so we've covered the theory. Now let's take a look at how these rules actually play out in a real courtroom and how they literally shape the entire trial process from start to finish.
So now when you hear a lawyer shout, "Objection," you'll know they're essentially flagging a rule violation for the judge. Objection, hearsay, means the witness is playing the telephone game. Objection, relevance, means we're back to talking about broccoli in a bank robbery case. Each one of these objections is a direct appeal to a specific page in that courtroom rulebook.
And these rules have massive, real-world consequences that protect all of us. Just take the landmark case Mapp v. Ohio. Before this case, if police conducted an illegal search of your home, any evidence they found could often be used against you in a state court. But the Supreme Court stepped in and established the exclusionary rule. That means if law enforcement breaks the rules to get evidence, that evidence gets thrown out. Period. It's a huge check on police power.
And to make things just a little more complicated, the specific rules can actually change depending on where you are. While all federal courts have one set of rules, the FRE, each state can have its own different version. A key area where you see this is with expert testimony. Some states use what's called the FRE standard, which just asks if a scientific technique is generally accepted by experts. But federal courts use the much stricter Daubert standard, which makes the judge a gatekeeper who has to carefully scrutinize the expert's actual methodology. That one difference can decide whether crucial scientific evidence ever makes it to the jury.
You have to remember this rulebook was written for a world of spoken testimony and paper documents, but today it's facing a whole new lineup of challenges that come directly from our technology.
I mean, just think about it for a second. How does a lawyer actually prove that a text message or a social media post is real and not some clever fake? The old rules for authenticating a handwritten letter don't really work. Courts all over the country are grappling right now with how to adapt these old principles to our new digital world, a world where evidence can be created, changed, and faked with just a few clicks.
And if we look just a little further ahead, the questions get even crazier. How do you cross-examine an AI algorithm that made a critical medical diagnosis? And what happens when a deepfake video of a crime is so perfect that it's literally indistinguishable from reality? How can a jury ever really be sure of what they're seeing with their own eyes?
The game is changing, and it's changing faster than ever before. The technology we use every day is evolving, and with it, the very nature of what we consider evidence. And while the core goals of that rulebook, fairness and reliability, those are timeless, but the rules themselves, they have to constantly adapt. Because at the end of the day, the search for truth depends on a rulebook that works for the world we actually live in, not the one we left behind.